We have both of our counsel with us at this point. Mr. Drake, my understanding is you are counsel for the appellant. Therefore, I would direct my inquiry to you. Did you wish to reserve any time for a rebuttal, counsel?
5 minutes, please, Your Honor.
Okay, I will attempt to find a good spot to do that. Don't start yet. I need to clear the time from the last case, or you would start with less than your full allocation. All right, I'm clear. You may begin.
May it please the court, my name is Ken Drake. I represent Kern Woolley. Catlin should be bound by their agreement. The court should enforce the party's contract and reverse the trial court's denial of our motion to dismiss.
And Mr. Drake, can I just cut to the chase? I'm
Please.
trying to understand what was the court's reasoning in denying the motion to dismiss. Did the court say anything in response to the mandatory forum clause that you had in the contract?
The court's order says that she denied the motion on the basis of the arguments raised in the plaintiff's motion response. Did not specify which or why. And so
that's because we have it right here, and it says what it says. And I guess what I'm trying to find out, if I may, and I apologize for not even letting you go through your argument. I'm trying to synthesize this. So I understanding this is a suit for basically a breach of the professional negligence. They brought suit against the firm saying that the services rendered was inadequate, and then laid out exactly in terms of the bad faith and leading them all up to the allegations. So I guess I'm trying to understand that, was there any mention, how do we get around the mandatory, strike that, how do we get around the mandatory forum clause? And how did the court get around that to come to this conclusion of denying your request? For
the trial court to get around the mandatory forum clause, the judge had to accept the Catlin's argument that it would be unreasonable and unjust to enforce the agreement because Catlin argued it was likely, and I put likely in quotes because that's their language, it was likely that the California statute of limitations, which would be applicable if they litigated in California. And as an aside, there's a law selection clause, it's the wrong words, that says that California law applies anyway. So it applies regardless of where we are. But in any event, the court had to accept that the unjust and unreasonable exception would apply where the law is unfavorable to Catlin, because maybe the California statute of limitations would preclude the suit, or the argument that, well, really, this is a tort claim, and so it doesn't arise out of the agreement, and therefore the tort claim is separate and apart, and so the agreement doesn't apply. And neither of those reasons should have been accepted by the trial court, and certainly shouldn't be accepted by this court.
Well, I guess going to the second about the tort, well, if you make the argument that the tort is the negligence that was caused by the professional, by the attorney, isn't that, how do you prove negligent? How do you prove that there's a duty? Well, you go back to the contract. There's a contract for services. And I guess it goes back to also the mandatory forum clause. I'm just trying to get my head around the reason that there's, and reviewing the record and in looking at what the conclusion is, I guess I'm at a loss. Just simply something is it would not be fair.
Well, I think that's the unjust, and Mr. Raines can probably express better than I his position, but I think that's essentially it. It's not fair to us, Catlin. Remember who Catlin is and what they do. This was a nationwide, it's a nationwide insurance carrier, not based in Florida, based in all over the country, essentially. Texas Incorporated, I believe, Connecticut Incorporation, main offices in Connecticut. Let me say this, main offices in Connecticut. They litigate all over the country. So the idea that it'd be unfair to litigate in any particular state doesn't really hold water.
Let me ask you a question about California as governing law for a tort claim. you refer to the governing law provision in the agreement. And what that says is the terms of the agreement shall be governed and interpreted in accordance with the laws of the state of California. So the terms of the agreement, does that mean California law would apply to a tort? And I get that there's a different argument on whether the attorney-client relationship, one way or another, depends on the existence of either a written or an implied contract. I'm talking about the governing law question. And you said when you were responding to Judge Kuzam that either way, California law is going to apply. And I want to hear a little bit more about why California law, based on this language, the terms of this agreement shall be governed and interpreted by, how we get to the conclusion that California law would apply to the tort, because I think that goes really to the fundamental question that Judge Kuzam is also asking, which is if Catlin couldn't bring this action in California because of the operation of the statute of limitations, then could that have been a reason the trial judge relied on? And if it was it right? But part of that depends on whether Florida law could be applied to the tort claim, I think.
Well, I think that, and I'm going to answer your question, but the beginning part of the question, the foundation of the question is that whether or not California law applies affects whether or not the forum selection clause applies. And we have not respectfully taken the position that the California law portion of that paragraph 813 affects the forum selection. It doesn't. But why would California law apply? Well, the second part to that is we've never litigated this in front of the trial court. The question of choice of law provision is not an issue that was raised in either the motion to dismiss, essentially, or the response.
No, I understand,
Okay.
but you're relying on the notion, or at least to some extent, relying on the notion that they would have the statute of limitations problem, even if this case stays in Florida, because California law is going to apply.
Well,
to these tort claims. You made that argument, and you just said it.
I would make that argument if we were back in the trial court. I'd make that argument. I'd make it because it rises out of terms of the agreement, and the agreement covers all aspects of my client's behavior, their conduct. Let me read a couple of notes. The agreement covers claim services, and this wasn't exactly legal services. We were lawyers, but we were providing claim services under the contract. This particular claim was assigned to Kern Woolley in 2016 to provide services provided under the agreement. We agreed to contract with, or they agreed to contract with us for servicing claims and insurance coverage related services. We investigate and evaluate claims, settle claims, and perform necessary work in connection with claims handling. It established our standard of care. It included broad, mutual, and identical indemnification provisions for literally any claim between the parties, and included, and I quoted this in the brief, any violation of fair claims practices, which really goes to the argument that there's some sort of bad faith issue here. I also argued in my brief, really in response to their position, that even if we applied Florida law, I think that the first injury rule would apply, and there's a line of cases, Kipnis out of Florida Supreme Court 2016, I think, and then followed just very recently by the Third District Court of Appeals in, I can never pronounce the name of the case. I think the defendant was
The Russian people.
What's that?
The Russian name.
Yes. Mikhailov or something like that. In any event, that in that particular case, the first injury rule applied, and therefore the argument, which really comes out of the old Blumberg and Teresito line of cases from 2000 or 2001, that as a result of that, relying on Kipnis, the Blumberg line of cases don't apply because in that particular set of circumstances, the injury occurred over 2 years before suit was filed. And I would argue here that if you use the facts that plaintiff says apply, we haven't fleshed those facts out at all. But if you use those facts, well, the same facts that would hold in California that the statute of limitations started to run, the severance of the relationship as far as handling the file, it ended immediately May 16th, 2016. The immediate damage, which is a damage I claim here, incurrence of the attorney's fees and having to defend the case, all that happened starting 2016. But okay, so my argument would be that if we were arguing application of the choice of law provision and why California law should apply, then I would say that it arises out of terms of the agreement, and the terms of the agreement established every aspect of the relationship of the parties, every aspect, and everything that my client did was governed by, controlled by, and established by that agreement. Unlike many of the cases that, for instance, the American Boxer case, where the release was the item that had the terms, that had the form selection clause in it, but that's not where the injury flowed from, and the negligence flowed from the running of this boxing match, and the release was secondary to that, I believe the court found. And in this case, the claims handling was arising out of the agreement for handling the claim services, which was the agreement that also had the form selection clause. So the idea here, and by the way, this is not an abuse of discretion standard. It should be applied here as argued by the plaintiff, Catlin. It's a de novo standard. The TICO Law Group case finds that, the Solomon Law Group case, the American Boxing case, even the 4th District in Bombardier rejected the abuse of discretion standard in a case like this. Back to Catlin, the merits. Catlin is a nationwide insurance company. I've told you where their principal place of business is. Kern Woolley's a California law firm. They had this agreement in place since 2009 to provide claim service for Catlin's nationwide aviation insurance program. The agreement says any and all disputes arising out of and in connection with this agreement shall be resolved in the appropriate federal or state court located in California. Any and all disputes arising out of and in connection with this agreement. And the agreement governs every aspect of the relationship, creates the relationship. And remember something as far as what the facts are. There's only 2 places we have information in this case. One is the allegations in the complaint. The other is the affidavit we submitted by the firm administrator who was in place and employed in 2009 when this agreement was executed. In fact, I believe she witnessed it. And in 2016, when this claim was assigned, she said it had been in place for 7 years. She said that, let's see, Kern Woolley, in 2016, Kern Woolley was providing services for Catlin pursuant to the agreement, including those services described in the amended complaint as being provided by the defendants. So the only fact in this case is that the services they say were handled negligently or in breach of the agreement, the standard of care in the agreement, those services were done pursuant to the agreement. All right.
You're at 13.
13. As far as the second reason then, well, where do I go? The idea that just because the law would be unfavorable to Catlin, because it's likely that the statute of limitations doesn't apply, should be a reason that would be rejected by
Isn't
this
what the
court.
trial judge said, that it would be unjust? And my concern is that as I go back and read Zapata, it talks about the power of the parties to contract for a court, in this case, an admiralty court, that would understand towing and all that, and are capable of doing it. It would seem to me that the California state courts can handle a legal malpractice case and are capable of doing it. And there's nothing necessarily unjust about that. And I don't know how broad this term unjust goes, but I'm not sure that as I read Zapata, which was relied on by the Florida Supreme Court, that that's what they're talking about, because the whole preface in that opinion was you should be able to contract. And if you can find a specialty court in London that does admiralty law and is going to give you a hearing, that's what you're looking for. It seems to me that there's a parallel between that and a state court that's capable of handling legal malpractice.
I can't disagree with anything you just said, Judge.
Be careful, everybody else can.
The fact of the matter is that California is not looked on as an oppressive jurisdiction to litigants. And they can certainly handle it. And whether or not any aspect of the law in the selected forum state may or may not be favorable to one party.
I guess my question is this: because a state court has a statute of limitations, does that make the forum selection clause unjust? And that's the burden that Mr. Raines' client has to demonstrate to the trial court, because if I read Zapata correctly, the clause selected by the parties is prima facie acceptable, and the one challenging it has the burden to show the exception to that general rule. And I'm trying to wonder what makes it unjust.
I don't
And
think
Zapata
anything
doesn't amplify on that, but I guess I reduced it. Does a statute of limitations make a forum unjust?
No, I don't think so. In fact,
Because Florida has a statute of limitations.
if you look at the Burroughs case, which is 1985 Supreme Court case, Florida Supreme Court, it allowed choice of law for the choice of law provision to be enacted, choosing the forum that had a shorter statute of limitations, or allowed the existence of a shorter statute of limitations by agreement, even though it may be in violation of Florida statute. So Burroughs, and we cited this in our
I've taken you into your time, but I want to let you know that I'm not charging it against you because you're answering my question. But now I kind of, since it's taken a minute of your time, I need to kind of ask you to sum up real quick so I can preserve your 5 minutes.
Thank you, sir.
Okay. And just so that we're clear, Mr. Raines, if you need an extra minute, you're going to get it too. I've tried to be as equal as I can running the clock so as to avoid being unjust. Mr. Raines, if you wouldn't mind, could I start with you on that one? Because I'm a believer in recency and primacy, particularly when the recency and primacy was my question. And as I go back to Zapata, I'm concerned that you have a burden to show unjust, if that's in fact the basis of the trial court. What makes a statute of limitations unjust, or am I applying the wrong standard when I pose that legal question?
Thank you, Your Honor. And may it please the court, I'm Garrett Raines of Baker Lopez on behalf of the Appellee Catlin Insurance. To address that question, I want to be clear. We're not arguing that any aspect of California law is unfair or is inappropriate, or any aspect of Florida law. Our complaint is not with the laws of California or Florida or the particular statute of limitations. The problem is that the statute of limitations in California does not work with Florida bad faith law. It's the problem of combining the laws of two states in a way that just stopped making sense. Because in Florida, the bad faith claim does not even exist until there's a judgment in the underlying case. And Catlin was not in a position.
Can I interrupt you, Mr. Raines? And
Yes,
I guess that begs the whole question. In this case, there was no bad faith result. There was no bad faith claim. You ended up winning the case. So what you're trying to do is to recoup whatever fees have expended. So how can you how can you say bad faith law doesn't really work in California? Well, it's not really bad faith. It would have been a totally different situation if, in this case, it went one step further, that the jury found a bad faith, conclusion, and then awarded a whole bunch of damages. Then we're talking about something else. But here it doesn't. There was no bad faith, period. And this is where I'm trying to reconcile your position, because basically the suit that you brought, you have a contract, and it's a breach of that contract. The services that was rendered, that contract is very clear about the choice, the mandatory forum clause. So it has nothing to do with bad faith, because we had no bad faith damages in this case. So help me out, Mr. Raines.
Yes. First, in response to that, the problem we had was that we were effectively defending a bad faith case until there was a judgment in our favor. And that is because the bad faith case would not
Doesn't
exist.
that really go, though, to your damages? And because you either were going to get a zero verdict, you're going to get a judgment under the policy limits where you're not going to get a bad faith, you're not going to get tagged with bad faith, or you would get a judgment that would result exceeding the policy limits, and there you are. But ultimately, any one of those scenarios are the damages that flowed from the malpractice that occurred when they made the unauthorized tender. And my question to you is, why wasn't the trial judge, or tell us why the trial judge wasn't bound by the third DCA's decision in the Mikhailov and Bills and Sumber case, where the basic conclusion was, if you know malpractice happened, and here you knew the malpractice happened, but you've got a few different scenarios where damages might become non-existent, be mitigated, whatever, but either way, your time runs from when you knew. And that seems pretty black and white here. So why shouldn't we follow that? And why wasn't the trial judge bound by it?
Now, as Mr. Drake has noted, what we're really looking at here is the court's decision to allow Catlin to remain in Florida at this point. So there have been no rulings on what law should apply here. There have been no rulings on what statute of limitations applies. However,
that's not my question. My question is, didn't you know in May of 2016 that the law firm had made an unauthorized tender? And wasn't that the act of malpractice? I don't care what law we're talking about. That's my question.
we knew that Mr. Kern had done something to expose our insured, Catlin's insured Niner X-ray, and Catlin to a potential bad faith claim. But that bad faith claim.
Well, you knew that Catlin had essentially breached the relationship by making an unauthorized tender. There's nothing else that happened that would have constituted malpractice.
Yes, Your Honor. And we also knew that everything that was happening from that moment all the way through judgment was potential evidence in a bad faith case. That an insurer's duty to act in good faith don't end with a certain action. They continue, and that bad faith case would accumulate all the way until a judgment occurred.
But again, that goes to
bad
the
faith
damages, not the causation.
The essential problem is that Catlin faced a decision of whether to pursue $1 to $2 million in litigation expenses and potentially damage a 9-figure personal injury defense, or to defend the personal injury claim completely and be forced, essentially, if Mr. Drake's logic is correct, to be forced to abandon a professional liability claim. That would
Well, we'll never know. We'll never know, because you didn't bring the action then, and you didn't try to see if something could be abated or something like that. But I am stuck on the third district's analysis and rationale that once you know about it, and I forget how the rules are labeled, but once you know about it, and it's a question of damages accruing, mitigating, increasing, whatever, the operative event in time is the day that you knew, which here was May of 2016.
In general, absent any issues of California law here, the way a claim like this would have proceeded is that Catlin would have defended through a judgment if there had been a bad faith, or if there had been extra contractual exposure due to a jury verdict. At that point, and not until that point, would Catlin have had the ability to bring, first of all, they would have been sued for bad faith, and they would have had the ability to bring a professional liability claim for those bad faith damages. In addition to those bad faith damages, Catlin would have been able to seek consequential damages. That is, the damages it incurred defending against the bad faith claim, defending its insured against a claim that didn't exist until Mr. Kern made his error. Because initially, the plaintiff was in the position to take $100,000 in policy limits, or to pursue a defunct corporation, Niner X-Ray Inc., which owned nothing but a now destroyed airplane. Mr. Kern's actions created a third option that was governed solely by Florida law and that the parties could not contract around. And that created a bad faith action. Now, ordinarily,
See,
the
and
way
I
that-
guess, Mr. Rains, this is where I'm having difficulty. You keep throwing the term bad faith, bad faith. What we're dealing here is a lawyer who was contracted to represent an insurance company to take care of claims, okay? There's an accident involving a plane that happened where somebody died. He investigates it, and his conclusion, he gives his recommendation to the insurance, hey, I think we should tender the policy limits of 100,000. Your client agreed, yes, and they said, whoa, but hold off. First it said, go ahead and tender it, but then later it said, hold off. Well, what had happened in the law firm, some paralegal who was out sick saw that, went ahead and made that offer. And then as soon as the lawyer who was being sued realized that, immediately withdrew it. Then it then became, it's like, was he authorized? He was not authorized to make that. And so bad faith under Florida is far different from the scenario of a breach of a contract that you know, your firm made a mistake in tendering the limits when they were not authorized to do that. So what I'm having a hard time is you're trying to inject a bad faith claim, and bad faith is very clear under Florida, where you have somebody that fails to resolve a case, you go into judgment and you get like a multi-million-dollar judgment, then you could pursue with that. We're not dealing with bad faith here. We're just dealing with a malpractice case based on a contract, and the contract that says that the forum clause mandatory forum clause in California. And that's where I'm having difficulty, Ms. Rains, and that's why I'm asking you to enlighten me as to why this is a bad faith claim. I don't see it as a bad faith claim.
Okay, well, let me make an effort then. What this was, Your Honor, was a bad faith defense, because this is aside from the terms of the contract. Here, it was essentially irrelevant what the specific terms of this contract were. What we know is, regardless of how he was, Mr. Kern was required to act in the contract. We know Mr. Kern attempted to make, or his office attempted to make a tender, and then, without consulting with Catlin, attempted to pull that tender back. We know that withdrawal of the tender, within 2 days, that the estate had filed a wrongful death claim against Catlin's insured. And we know that after that point, the plaintiff's attorney indicated he would never accept the policy limits. And in fact, after that point, there were no negotiations at the policy limits. The parties were discussing extra contractual exposure. Any offer made by Catlin was, I think it was a $500,000 offer discussed in the complaint. All of the amounts discussed were extra contractual because a new claim existed. This bad faith claim was, it had not come to fruition. However, Catlin was defending it. And everything Catlin did from the moment of Kern's attempt to withdraw that tender all the way through a judgment was all potentially evidence in a bad faith case.
And ultimately, though, they won the case. The jury found that there was nothing there. So again,
Yes.
It begs the question, is it really bad faith? They're trying to recoup the defense cost that they have expended. And I guess that's my concern, Mr.
Let me
Rains.
Sure.
phrase it in a different way. Is it a bad faith merely because the plaintiff's lawyer uses the term bad faith? Or as Judge Kazam saying is, this is arguably a breach of contract case that you had to try because a third party, the plaintiff's lawyer, called it bad faith. All these damages result and flow from what is alleged to be a consequence of the breach of the contract. And that's, I think, is what our concern is. And if it is, I share.
You said it beautifully, Judge Casaweber. Thank you.
We better mark it down that I finally got something.
The bad faith case exists as a reality. We know that most bad faith cases are settled long before they reach judgment.
Is it a case or a claim? It's an assertion.
It's an assertion. However, that assertion could not have existed until Mr. Kern withdrew his tender. And again, that created a claim that didn't exist. Until then, the estate had no choice but to either collect the policy limits or to simply sue a defunct corporation. That created a third option. Now, it didn't vest until a judgment. And it wouldn't have vested until a judgment, but everything that was happening from that mistake all the way through the judgment was all evidence of Catlin's claims handling, of the potential of bad faith claims handling. So Catlin faced an impossible choice of, do we risk $100 million judgment by conducting discovery on an ongoing bad faith case? Or do we defend our insured, spend every cent we need to defend our insured in the best possible way and prevail on the case? And that's ultimately what we chose to do. However, if the claim,
It's
if there had been a
interesting.
bad faith, sorry.
No, interesting, Mr. Rankin, because Judge LeBrit raised an issue too. You could have brought suit in California and asked the court to abate that decision. You would have preserved the statute of limitations. Then you could have gone through and handled all of that here, and that wasn't done in this case.
That's true, Your Honor. I don't think there's any question from the briefing that Catlin was aware of a potential professional liability claim early on, all the way from 2016. And Catlin made the choice not to sue in California and not to sue within California statute of limitations. And Catlin made that choice because perhaps if this was a $50,000 claim, it's different. But on a claim of this magnitude, we could not do anything to create additional risk to our, first of all, to our liability claim, our defense of the liability claim, but second of all, to create additional evidence of bad faith. We could not conduct discovery on this bad faith claim while it was happening. It was too dangerous. So we certainly could have filed suit, and we could have taken that risk as a business decision. That would have been a horribly dangerous decision. And certainly Catlin would, when weighing several $1 million potentially in defense versus an 8 or 9 figure personal injury judgment, Catlin's choice is to protect itself against the 8 or 9 figure personal injury judgment. There really was no choice. Catlin had to defend the claim, and it had to find out whether there was a bad faith claim in the first place. Now, once that happened, Catlin, if there had been extra contractual liability, then Catlin would have been able to sue, bring a professional liability claim. I don't think there's any question that, at least in Florida, once there was a judgment, Catlin would have been able to sue. It would have been entitled to not just those damages, though, but also the consequential damages of having to defend the claim. Catlin's position, and again, this is something that's not yet been determined by the court here in Florida, but Catlin's position is that even though it prevailed on the bad faith, it should still be entitled to these consequential damages that it incurred, and for which it simply couldn't bring a claim until there was a judgment as a matter of business. Something I'd like to briefly address is the standard of review, because that was also mentioned by Mr. Drake. There's no question in terms of interpreting this contract, it is a de novo standard of review. There's no dispute there, but there are 2 issues here. One is how the court, and again, because we made 2 arguments, and the court ruled in our favor based on our arguments made. Our first argument was the interpretation of the contract itself, that the facts surrounding this bad faith claim do not fall within the contract. That's a contractual interpretation issue. That's de novo. The second issue, however, is the court's application of this exception, determining that it was unreasonable and unjust under the circumstances of this claim. And not unreasonable and just as for all purposes, but for under the circumstances of this claim, that it was unreasonable and unjust to apply this forum selection clause. And we've cited 2 cases in our brief. W.R. Grace v. Multi-Restaurant Concepts found there was no abuse of discretion, in trial court's ruling that enforcement of a contract would be unreasonable and unjust. And this court addressed that issue in Straight v. Yorba Linda, where it applied an abuse of discretion standard to the question of whether to enforce a forum selection clause. And I think the specific language, Kern Woolley cited management computer controls. The language in that case actually addressed different cases in which an abuse of discretion standard versus a de novo standard was made in forum selection clauses. And the language used by that court was a reasoned judgment based on the facts and circumstances requires abuse of discretion. And so with respect to the court's decision that this was unreasonable and unfair under the circumstances, that would be under an abuse of discretion standard.
Was the last matter you cited the opinion drafted by Judge Lucas? Because I have a hard time pronouncing one of those names, and I wonder if that was it.
Oh, the management computer controls?
No.
I'm sorry. Straight v. Yorba Linda.
Muley? No, that was not it, because that's a Solomon Law Group. We would be using
Okay.
that title. Okay, I got you. I was looking at the wrong case. I want to make sure that I was getting to the right one.
Yeah, so I should say with Solomon Law Group, again, did not involve an issue of bad faith. We're not arguing that no professional liability claim would fall under this forum selection clause. And we're not arguing this forum selection clause is unfair. We're arguing that the way Florida and California law happen to mingle here, it no longer makes sense because Catlin, as a business matter, is precluded from bringing any claim to recoup its losses until the statute of limitations has expired. So for those reasons and the reasons on our brief, we request that the court affirm the lower court's decision, and thank you for your time.
Thank you, counsel. Clear that. Mr. Drake, you have your 5 minutes remaining, sir.
Let me kind of bounce around. I've been unable to get my head around their argument that filing a lawsuit in California against my client would have somehow endangered their defense of their insured in the underlying case. I don't understand that. They've not articulated that. It doesn't make sense. It couldn't even be used, as far as I can think, as evidence against them if there was a bad faith claim years later. And as Judge Kusan points out, this isn't a bad faith case. It's a claim for recouping defense costs. Defense costs, by the way, that they were obligated by contract to fund, because that's what insurance companies do. They defend lawsuits. This is a lawsuit to recover their defense costs incurred, they say, because the plaintiff in the underlying case rejected their tender, which was made soon after my client was severed from the relationship, and Florida firm, which I believe is Mr. Rain's firm, got involved and they tendered. But they say it was rejected because the plaintiff now was going to allege there's bad faith. And you know, it's speculative what this underlying plaintiff would have done with $100,000 limit and a multi-million-dollar case. And we all know that bad faith claims are made all the time and litigated for all sorts of reasons. So for them to speculate that they would have taken the 100, but for the fact that my client withdrew the tender, I don't know that the court should rely on that. They have not told you why it would be unjust to litigate these very same issues in California. They haven't. Nationwide Insurance Company litigates all over the country, could have filed a lawsuit against my client in 2016. And by the way, they say the evidence of the breach, the evidence was accumulating over time throughout the entire underlying case. That's not true. The evidence as to the breach was completed by May 16th, 2016, when my client's work was done and the file was transferred. Everything that they allege in the complaint that establishes the existence of a breach of the agreement, Their standard of care was breached. The fact that they claim that we improperly tendered and then improperly withdrew the tender, that all happened in May of 2016, and nothing after that affected that finding. Those facts are set in stone. What they, and I believe the entire panel has recognized, is what they're really saying is there may have been some other damages. You know, in 2025, if we had the litigated bad faith case and that was concluded, then we might have more damages. And the answer is they should have filed the lawsuit because they knew there was a breach. They knew they were dealing with California statute of limitations, assuming it applies in this case and assuming that it would bar the claim. They knew they were taking that risk and they chose not to do it. They could have filed the lawsuit, put it on, asked for it to be abated or stayed, and litigated the case in California as they were supposed to and as they agreed to. It's not unjust. There's no bad faith claim. And by the way, if you notice, counsel started to walk back away from the fact that the statute of limitations really would bar their claim. They're not conceding that. They're just saying it may. Well, let them litigate that in California is my response to that. The order of denying our motion to dismiss should be reversed. Order should be entered indicating that the case should be brought in California as they contractually agreed in 2009. Thank you.
Thank you, counsel. Thank you both. Historically, it was interesting to look at Zapata in 1972 opinion. My recollection is former President George H.W. Bush was involved in the creation of Zapata oil. I'm not certain. It's been a long time since I read, but at one time that he was a Texas businessman, and I think it was with Zapata oil. But, you know, the historians will check me out and find out if I'm accurate or not. So with that said, thank you very much. Be safe, and we hope to see you again in the future.
Well,
Thank you,
and,
Your
with-
Honors.
and really,
Thank
I
you.
echo that. Well argued on both sides. Very well done. Thank you both.
Thank you. all.
Thank you.
Let's see. I think we have to leave.